Carol. Good afternoon, everybody. Thank you so much for joining us. Happy virtual reunion. As Carol said, I'm Steve Vladeck from the class of 2001. Hard to believe this is our 20th reunion. But the idea for today was that Paul Smith and I'll introduce Paul in a second, we'd get together and just have a conversation about the Supreme Court and the 2020 election, which I think has both obvious importance and ramifications, not just from a historical perspective, but with regard to where we go from here. So let me sort of start by introducing Paul Smith, who really is someone who needs no introduction, but I will do it anyway. Paul is a graduate of Amherst College, the class of 1976, and also a parent of a graduate of the class of the 2009. Paul is a member of the Amherst College Board of Trustees. Paul's day job is as Vice President for Litigation and Strategy of the Campaign Legal Center. He is a incredibly highly regarded and veteran Supreme Court and federal court litigator of all things election law and otherwise. He's argued before the Supreme Court, I think 21 different times, Paul, right, including the landmark cases of Lawrence versus Texas, Brown versus Entertainment Merchants Association. But it's especially relevant here, Paul also argued a number of the major election cases that came up last year. And so, Paul, thank you. I think this is, in thinking about who I'd want to have a conversation with about the Supreme Court and the election, I think the list starts and ends with you.
Well, thank you. I should note that Steve is a very eminent law professor who is going to bring great expertise here as well. So, despite that top introduction of me, we should feel lucky to have Steve as well.
I forgot to introduce myself. So I'm Steve. I said I'm Steve Vladeck, 2001. My day job is I am the Charles Alan Wright Chair in Federal Courts at the University of Texas School of Law, and a wannabe Supreme Court litigator. So, so Paul, I thought it would make sense just to dive in. So when you and I spoke about today's panel, we really broke our sort of planning into 3 phases, right? And phase 1 was basically the road up to the election, sort of both before last spring when COVID really started to ramp everything up and after. So can you say a bit about sort of like where you were, right? Like March 2020, what you were expecting with regard to what role the Supreme Court was going to play in the election, what some of the disputes were going to look like, sort of table setting. What were your expectations going in?
Well, we knew that 2020 was going to be a very controversial and hotly contested election, and that meant there would be states out there trying to find ways to suppress votes to gain a marginal advantage in the election. And the Campaign Legal Center, where I work when I'm not teaching at Georgetown, we have a whole group of people whose job it is to go around and bring lawsuits about, improper purges of voters, improper other ways in which people are prevented from voting. We knew this would be happening, and we got geared up, hired some new staff, et cetera. What we didn't know is that it would all be done through the lens of the COVID pandemic, which comes on right in March, right as the primary season is getting going, and becomes the major theme of the election year until we got right close to the election. And the whole issue was what can be done to make it easier for people to vote in a pandemic. And this was a really fascinating situation, because obviously there were lots of people, especially if you think about what it was like last spring, who really didn't want to go to a polling place, were staying home, wanted to vote by mail. And so we started to see this massive increase in voting by mail. And that led to lots of legal issues about that aren't so important when maybe 3 or 4% of the people are voting by mail. But if half the votes are being cast by mail, the question of how you verify those ballots becomes enormously significant. And there were a number of states that, for example, said you had to go find somebody to witness your signing of your absentee ballot. And that meant that you had to have somebody in your home, or go to somebody else's house, or some other way get in the presence of somebody if you were living alone, especially. And so the question was, can those requirements be waived? There were states in which they would verify your ballot by looking at the signature on it. And if they decided it didn't match the one they had on file, they would just toss the ballot and not even tell you about it, not give you an opportunity to come and say, I really did cast that ballot. So we started to bring lawsuits, us and the Democrats and lots of other people bringing lawsuits to try to make sure that people had the opportunity to vote by mail, that they would get the ballots on time, that the verification systems would be relaxed so that people could feel comfortable voting in the pandemic. And these cases start bubbling up through the federal court system all over the country, in blue states and red states. And in many of those states, the election officials were quite happy to cooperate in relaxing witness requirements and relaxing in making sure people had an opportunity to cure if their ballot signature didn't seem to match, making the ballots available more easily for people. And then there were other states that were not the least bit interested in making it easier for people to vote in the pandemic. And so these became hotly litigated matters. And eventually a number of them found their way up to the Supreme Court. And the basic theme of this part of the period of time we're talking about here was the Supreme Court slapping down federal judges for getting too involved in the details of how people vote, changing deadlines, changing the rules for witnesses, changing the rules for opportunities to cure signature matching. And the court very aggressively used what Steve has called it the shadow docket, which is one of Steve's expert things, to stay a lot of federal court orders and say, you Mr. Federal Judge or Ms. Federal Judge have no business second guessing the decisions being made in this difficult time by all these state election officials about what adjustments they should make or shouldn't make to make it easier for people to vote. We think those judgments are going to be better made by the election officials themselves rather than by a bunch of federal judges. And we especially don't like it when you make those changes at the last minute. That's disruptive. And so we had a long series of stay applications being granted by the Supreme Court and effectively overturning federal court decisions that were attempting to make it easier for people to vote. And that became the main theme of the period of time, say March through until October. We can elaborate on that some more, but I just wanted to get that on the table.
And Paul, that's what I mean. It seems to me that we also see during this, we see during this time period, the court, as you say, hostile to federal judges who are indulging late COVID-related changes, but not hostile to state judges, right? And
there weren't that many state cases early on. This kind of came along more right around the election, particularly in a bunch of fighting about the Pennsylvania Supreme Court.
Sure.
But no, these were all being filed in federal court, and they were very hostile to federal judges. The exception was if the state election officials entered into what's called a consent decree, a settlement, and said, we're happy to relax this requirement or that requirement, and we'll put it into a voluntary court order. In one of the cases we did involving Rhode Island, the election officials agreed to get rid of their witness requirement, and the Trump campaign came in and said, no, we want to keep that witness requirement in, and they took that up to the Supreme Court. And in that one, the Supreme Court said, look, if the election officials agree to this, we're not going to stay that. Our whole theme is let the election officials decide it. You Republican Party and Trump campaign shouldn't be able to push them around. But generally speaking, it was the federal judges who were trying to do this. And the one that everybody heard the most about was the Wisconsin primary, in which the federal judge had ordered that because the absentee ballots had been delivered so late, people should be able to put them in the mail after Election Day. And the Supreme Court was not amused by that, 5-4, said you simply cannot, as a federal judge, order a state to allow people to vote after Election Day. Maybe you can change things about when the ballots have to arrive, but you can't have people voting after Election Day. And they pointed out that that meant that people would know what the results were before they were casting their vote. And so the federal judge had also entered an order saying you can't publicize the results until a week or two after the primary election. And so this became the real big first salvo of the courts slapping down federal judges way back in the spring.
So you said the first salvo, but also, it's interesting that it also is the only time in any of these election cases that we get an opinion for the court, right? It's a short one, it's unsigned, but the Wisconsin primary case is the only one of any of these election cases, right, that produces an opinion.
Yeah, we had a little paragraph here and there, but yeah, that's basically right. Nothing that you would call a real opinion of the court. And some of them, you just get a one-line order. That's the way the shadow docket works.
Well, and this is one of the criticisms of the rise of the shadow docket, is that the court is deciding what are pretty significant disputes, right? In a context in which it's not exactly providing a lot of guidance, either to the parties in that case, or more importantly, right, to sort of other states and other officials and other courts about what to do in similar contexts.
Yeah, and a lot of these fights were not hugely consequential in the sense that they affected tons and tons of votes. But there were a couple that really were. One of them I just thought I'd mention. We litigated, along with a lot of other people, a case against Texas. Texas has a law that says you can vote absentee as a matter of right if you're 65 or over. If you're under 65, unless you can prove that you have a major disability or you're going to be out of the state, you can't vote by mail at all. And there was a huge fight about that, because in a time of COVID, people wanted to be able to vote by mail. And there were lots of people in the under 65 category who were trying to figure out how they could cast a vote without having to go wait in line and go into a polling place. And Texas just adamantly refused to relax the requirement. And it has this whole political aspect to it, because if you look at who are the people who are over 65 versus under 65 in Texas, the over 65 crowd is predominantly Anglo conservative, and the under 65 crowd is much, much more diverse racially and politically. And so it was a way for them, if they could make people show up to vote, to suppress voting in the younger ages, which would probably be more Democratic voters. That issue was won in the district court, and the Court of Appeals stated, and then we went up to the Supreme Court, and they said, we're not going to do this. We're just not going to fix this problem, even though it seemed like a really unfair feature of a law in a year when 40–50% of the votes would be cast by mail if people could do it. But they simply weren't able to do it. And so, there were some of them that were quite consequential. And Texas didn't turn out to be a particularly close state in most of the races, not nearly as close as people thought it would be, but it could have been absolutely outcome determinative. It probably prevented 1 or 2 percentage points of voters from voting at all if they had to go to the polling place.
So I want to fast forward a bit, because obviously there's a lot of stuff that happens over the summer. One of the most important things, I think, in retrospect, right, is of course the unexpected passing of Justice Ruth Bader Ginsburg in September, which leaves the court down a seat, right, for the next 5–6 weeks, including all of these major sort of pre-election cases. Can you say a bit about sort of what happened, in that last sort of crazy period, the month before the election, especially the, sort of South Carolina, Wisconsin, Pennsylvania, what the broader takeaways were?
Well, we continued to see this pattern of the Supreme Court being very hostile to federal courts getting involved in these things. And South Carolina was a particularly notable one. The federal court had gotten rid of their witness requirement for mailed-in ballots, and that got slapped down, but it didn't get slapped down until after many of the votes had been cast. And so even among the conservative wing of the court that had voted to overturn that order and reinstate the witness requirement, the question was, what do you do about all those voters who had cast a absentee ballot without getting it witnessed in reliance on the federal court order? And 3 of the justices said they would have gone ahead and had those votes thrown out. 2 of the others.
Did that surprise you?
Yeah, no, I think it's one of the things that became a theme in this year. Judges should be reluctant to throw out votes cast in good faith by voters who were following the rules in effect at the time they cast their vote. And this is what a lot of the post-litigation litigation was trying to do. So I think it's quite surprising. And we saw Justice Kavanaugh and Chief Justice Roberts say, no. We have to let those votes count. But the fact that there were 3 justices, Gorsuch, Alito, and Thomas, who are willing to throw out votes because the federal judge made a mistake, not because the voter made a mistake, and not because there was any real reason to think these were fraudulent votes at all, was I thought, quite shocking, and an example of potential problems to come in the future. So we had that case. And in Wisconsin, we had this continued issue of changing the deadline for absentee ballots, and they again held in the Wisconsin case in October that the federal court should not be lifting the requirement that absentee ballots in Wisconsin show up by election day, that the federal court had no business saying that that's a necessary thing in order to protect the constitutional rights of voters. And they pointed out all the other ways in which Wisconsin had already made it easier for people to vote early, to vote by mail, et cetera, which was actually quite true. Wisconsin had done quite a bit to make voting easier. And so we had some opinions in that Wisconsin case, concurrences and dissents, in which we started to see the emergence of a conversation among the justices about something called the independent state legislature doctrine. Even though that case had really very little to do with that, since it was really about a federal court, maybe I'll let you do some talking instead of just asking questions, explaining to people what the independent state legislature doctrine is.
Sure. I mean, so I think this is actually one of the more important sort of longer term constitutional ideas, right, that comes out of the election.
Yeah.
So, you know, the Constitution talks about state legislatures in two places when it comes to elections, right? That first, Article 1 provides that, you know, state legislatures are tasked with the charge of setting the time, place, and manner, right, for elections, including to federal offices. And then, of course, Article 2, which talks about the state legislature's responsibility for providing by law for the appointment of electors to choose the president. Indeed, the method of appointment. And of course, the question becomes, is that exclusive of state Supreme Court? So put another way, right, does the federal Constitution, by giving state legislatures the power to provide for the method of appointment for presidential electors, mean that state Supreme Courts have nothing to say? If the state legislature does something that's in violation of state law, right? If the state Supreme Court holds, as the Pennsylvania Supreme Court did, that mail-in or absentee ballots that are dispatched by election day must be counted if they're received within, I think, Paul, 3 days, right, of election day in Pennsylvania. The Pennsylvania Supreme Court says the Pennsylvania Constitution required that, even though the legislature had only provided that the ballots would be counted if they were received by election day. And so the question becomes, in a dispute between the state legislature and the state Supreme Court about the meaning of the state constitution, does the federal Constitution have anything to say? And I think it's safe to say that for a long, long time, the assumption has been that the answer is no, that on questions of state constitutional law, state Supreme Courts have the last word. But the so-called independent state legislature doctrine is an idea that first really received prominence in Chief Justice Rehnquist's concurring opinion in Bush versus Gore, that the Constitution, by giving this role to state legislatures, is actually excluding state Supreme Courts and is barring state Supreme Courts from enforcing the state Constitution against the state legislature. In other words, right, that the state legislature has primacy even if the state constitution is to the contrary. In the Wisconsin cases, right before the election, Justice Kavanaugh drops a footnote to a concurring opinion where he really revives this doctrine, where he says, you know, Rehnquist was onto something, like this is a big deal. Even though, as Paul says, that wasn't central to the question in the Wisconsin case. It was a much bigger deal in Pennsylvania. Yeah. And part of why this is such a big deal, guys, is because, you know, taken to its extreme, this doctrine would mean that if there are snafus on election day and a state court says, oh, well, we got to keep polling places open later, right? They would lack the power to do that if the legislature had provided otherwise. And this is why this is so potentially problematic. Also, stepping back for a second, from a con law perspective, the notion that the federal Constitution fundamentally restructures the relationship among branches of state governments, I think would have been a big surprise to the drafters of the federal Constitution and to the states that ratified it. So, Paul, that was like the big con law issue looming over these cases that the court ducks, at least for the moment.
Sort of, yes. And let me just try to elaborate on that first so people understand what's important about this. the argument that is made in the is that if a legislature has mandated some rule for the elections as a matter of state law, any variance of that by the state courts or by state executive branch election officials, either one, is not only a violation of state law because it's inconsistent with whatever the statute said, the state statute, but is also a violation of the federal constitution. And what that does is it means that the federal courts and the Supreme Court get to decide when state Supreme Courts have violated state law, when state election officials have violated state law. It federalizes all these issues of state election law and makes the federal courts and the Supreme Court into this sort of super election administration agency of each state. And so this became a big fight in this Pennsylvania case right around the election because the Pennsylvania Supreme Court had, in direct contradiction of the state law that the legislature had passed, given 3 extra days for the absentee ballots to show up, saying, well, we have the authority to do this under the state constitution because it's an emergency. And there were justices, as this case kept coming back up to the court, with the Republicans were trying to stop this. They thought those 3 extra days of ballots might change the outcome in Pennsylvania. As those cases kept being filed, the justices started weighing in on this and saying, we think this is a very serious federal constitutional problem that this Pennsylvania Supreme Court has given these 3 extra days.
And indeed, and Paul, and the court splits 4-4, right? I mean, so there's an effort to get a stay of the Pennsylvania Supreme Court decision that had extended the deadline by 3 days. And without Justice Ginsburg, with an 8-justice court, I think in mid-October, there's a 4-4 split.
There is, because Chief Justice Roberts goes and votes with the liberals and is much more moderate on this issue. But then they come up and they ask the court to grant review on the merits right before the election and overturn this Pennsylvania Supreme Court ruling. And there was a dissent written by Alito, joined by Gorsuch and Thomas, which also, like Kavanaugh, endorses the independent state legislature doctrine. And so we have 4 conservative justices saying, we have the authority to review the Pennsylvania Supreme Court's interpretation of the state constitution to see whether, in fact, they have gone too far in overruling the legislature's deadlines for the election. And if it wasn't for the fact that Barrett wasn't voting yet, because she had just been confirmed by election day, and Roberts had taken the other side, we might have had this massive fight right before the election. It turned out there weren't all that many ballots that showed up after election day, and they were kept segregated. And when this issue started coming back up to the court after the election, there was ultimately only one justice, Thomas, who thought they ought to go ahead and decide the merits of that controversy, whether Pennsylvania Supreme Court had in fact violated the Constitution. But that's in part because by then we knew it wouldn't make any difference, that there was simply the margin of victory of Biden in Pennsylvania was large enough that these absentee ballots that were kept in a separate box and could be counted or not counted, depending on what the court held, wouldn't make any difference.
So I mean, to put this in context, right? So we get to election day itself, having seen this remarkably busy flurry of activity at the Supreme Court in election cases from Wisconsin, Pennsylvania. We haven't even talked about North Carolina, right? And I think, it was not out of the sort of realm of possibility to think that, okay, well, if that's what they were doing in the weeks leading up to the election, this election is going to end up in the Supreme Court, right? That we're going to see this on the far side too.
Well, of course, and that was being said almost every day by President Trump, who said this was the reason why we have to get Justice Barrett confirmed. They're having the confirmation hearings in October of the election year.
While people were voting.
While people are already voting, Trump was saying this is important because this election is going to be decided by the Supreme Court. And we don't want any more of those 4-4s like we had with Roberts switching sides in the Pennsylvania case. We need to get her on the court. And everybody had fully expected that this might be the year when we see a repeat of 2000, when the Supreme Court did in fact decide who won the election. And so this becomes very fraught. And what this independent state legislature doctrine does is it gives the Supreme Court a great deal of additional power to intervene, to decide issues that wouldn't ordinarily be viewed as having anything to do with the federal Constitution. And it's typically going to be things where election officials or state courts have tried to expand voting by either making it easier to vote or maybe giving you more time to count the votes. That was what the issue was in Bush versus Gore, stuff like that. And then the Supreme Court can come in and say, no, we're going to be sticklers. We have to live by the letter of the statute, the state statute, and we're going to enforce that. And so you can't expand voting. And so there was real fear at that point that we would have cases after the election in which the argument would be made that either state election officials or state courts had gone too far in opening up voting, and that votes would start to get taken off the table after the fact based on this doctrine. And that's in fact what the Trump campaign in state after state was asking to happen.
So I want to get back to that, but I just want to, I think it's worth underscoring a point that I think we've already made, but I want to say again. I mean, one of the things that I think is especially important about the independent state legislature doctrine is it has nothing at all to do with fraud, right? Like there's no connection whatsoever between a claim that the wrong state official adjusted the voting rules and the claim that individuals who are not eligible to cast a single lawful ballot casted ballots that were then counted. Like there's just the disconnect between the public discussion of this litigation and the actual substantive constitutional arguments being presented grew right as time went on.
Right, and this continued all through the post-election period as we had case after case being filed, almost all of them saying not that there was any evidence of fraud, but that instead the election officials of X state or the state courts of X state had gone too far to make it easy to vote, and they were violating the technical rules of the legislature. And so under this independent state legislature doctrine, you should pull some of those votes off the table, even though they were cast in reliance of the rule on the rules that were in effect. That's what all the Wisconsin litigation afterwards was about, for example.
And most of Pennsylvania.
So all this idea of fraud is all people didn't, when Rudy Giuliani would show up in a court and they said, do you have any claims of fraud? He said, no, we're not talking about fraud.
Right. So I guess the question is then, given the buildup, right, are you surprised at how little the Supreme Court did after the election, which is to say, nothing, right? I mean, there was not a single order issued by the Supreme Court granting relief to anybody in a post-election challenge to any state's election results. There were some pretty high-profile denials of applications for relief, including the denial of Congressman Mike Kelly's effort to have all of Pennsylvania's absentee ballots thrown out. My buddy, Texas Attorney General Ken Paxton's effort to have the Supreme Court use its original jurisdiction.
You and he are tight.
Oh, I mean, he only blocked me on Twitter in a friendly spat. So, I guess my question is, given all of that, were you surprised that, from November 3rd to like today, right? The court, this court, especially a court with Amy Coney Barrett in what had been Ruth Bader Ginsburg's seat, stepped back and was like, we're not touching this with a 10-foot pole.
No, it turned out the election wasn't close, and that Biden had won a margin of victory that meant that in order for the court to have any consequential intervention, they would have had to overturn large numbers of votes cast in good faith in a bunch of different states. And so we didn't really have a situation where the court was presented with the opportunity to actually change the outcome. If it had come down to one state and that state had been a couple thousand votes, and those 2,000 votes were because they were allowing absentee ballots to be collected after the statutory date or some other specific thing like that, the court might very well have intervened. Indeed, all of the rhetoric of the conservative wing of the court, Roberts aside, and Barrett didn't say anything, but the other four was very aggressive against state courts and state election officials not following what they perceived to be the letter of the state election code, and strongly claiming the right to go in and enforce it. And then we had that South Carolina case I mentioned, where 3 of them were willing to take votes off the table that had already been cast. And so, if it had come down to that, and I think this is the message coming out of this, if it had come down to that, there's every reason to think the court might very well have come in and played a very consequential role in deciding that these votes can't be counted, and this state should be awarded to, the decisive state should be awarded to, it would have probably been Trump, because they were the ones who wanted to get votes off the table, and it's Biden who wanted to keep every vote on the table. But
do you think it also, though, I mean, can I throw out another possible explanation, which is that at least on the far side of the election, the court was also of the view that the lower federal courts and the state courts that had heard the post-election cases have largely behaved responsibly, that, like, unlike in 2000, where I think some of the conservative justices were genuinely of the view that the Florida Supreme Court was trying to steal the election, there was none of, like, the lower courts behaved well right after the election, which may have had some bearing on sort of making it easier for the Supreme Court to feel no obligation to step in.
Right, I mean, that's true, but that was in part because the election margin was large enough that the Trump campaign lawyers had to come in and make these really aggressive asks.
Right, every mail-in ballot in Pennsylvania.
The Giuliani case was asking for every mail-in ballot taken off the table. So was the Kelly case you mentioned. So that would have been like 1 million people's votes just thrown in the garbage. That's a pretty aggressive ask after the votes have already been cast. And much the same was true in Arizona, in Nevada, in Georgia. Yeah. And so, they had a goal in mind, which was to change the outcome. And in order to do that, given the margins, they had to come in and make those kinds of aggressive things. And the courts, to their credit, said, you don't even remotely have the kind of claim that would justify us in intervening in this kind of way. I mean, and some of the most aggressive opinions written rejecting these arguments were written by Trump appointees and other very, very conservative Republican appointees. The Third Circuit in Philadelphia wrote one in particular in the big Giuliani case, in which he was using a minor technicality to try to justify throwing out all the mail-in ballots of Pennsylvania and change the outcome. And they were just not having it. And so you're right. I think that the court didn't feel like there were courts out there that were trying to string it out in order to produce a particular outcome. There really is a sense in which I think the conservatives on the court worry that liberal federal judges and liberal state courts are going to try to mess around with the process to get toward a particular outcome. And I think the sort of which courts are being partisan is a little bit in the eye of the beholder in all of these cases, because the conservative side would say, in Bush v. Gore, that Florida Supreme Court was just out of control. Somebody had to shut down that process, and and I think in this year it was the federal judges in Wisconsin and other places that the Supreme Court thought were a little bit out of control, getting too aggressively involved in changing the rules in the time of COVID. And they thought that the Pennsylvania Supreme Court really shouldn't have done that with the three extra days for the absentee ballots.
But I want to sort of underscore the point about the margins, and just I think as an election lawyer, I don't think this is a surprise to you, but I think for a larger audience, the sort of the availability of claims to contest an election, right, is inversely proportional to the margin, right, where the closer the election, the more there's room to argue. And so just by comparison, right, Florida, when the recount stopped in 2000, the margin was, I think, 537 votes. The closest state in 2020, right, was Arizona, where the final margin was over 10,000. So we're talking about a factor, a difference of a factor of 20. And as you said, I think quite rightly, right, and even flipping one of those states wouldn't have made a difference.
Right. And, people do talk about how close the election was. And, you can say, well, you changed 40,000 votes in 3 states, you could have changed the outcome. And that's true. But if you're talking about using litigation to get rid of a margin of victory, if it's more than about 1,000 votes, that very rarely ever changes in a recount, for example.
So I think so. That I think is an incredibly, I think, persuasive and satisfying explanation for why the courts didn't do more after the election. But I want to flip it over and sort of raise a point that our mutual friend Tom Goldstein raised very loudly in public, which is So Tom Goldstein, for those of you who don't know, is a prominent Supreme Court practitioner and co-founder of SCOTUS blog, which is one of the, I think, the central repository of Supreme Court news and developments. And Tom wrote, Paul, two very unusual for him, what he called editorials. First, right before the Supreme Court was set to decide whether to hear Texas's bizarre original lawsuit against Pennsylvania and 3 other states. And then second, when the court was sitting on all of these other sort of appeals in Georgia, Pennsylvania, Wisconsin, and there were these motions to expedite. And the second one came the night of January 6th. And Tom's point, the first time that he amplified the second, was actually that it was important for the Supreme Court to say something to actually diffuse the fraud narrative, the stolen election narrative, that even though it would have been unusual as a doctrinal matter, the court might have been the one institution with the credibility to speak to, especially, Trump's supporters and say, guys, there was not this election was fair and legitimate. You should accept the results. I'm curious what you think about that argument and whether we would have been better off if the court had taken the rare step of saying something like that.
Well, given that we still have a very large percentage of the population who thinks the election was stolen and that President Biden's illegitimate, if the Supreme Court had found a way in which to weigh in, I think that could have been extremely beneficial. It would, however, have been very unusual for the court that typically denies these emergency applications in one-line orders, or in the case of that crazy Texas thing, which involved the votes of other states. They wrote a sort of 1-paragraph standing opinion, which means that there was not a cognizable injury by Texas, but came off as a very sort of evasive, not a merits-based decision. Didn't really help with the situation. So I'm sympathetic with Tom's point. Given all the rhetoric of fraud and stop the steal and everything, it would have been a useful thing for the court to do. But of course, that doesn't. They're trying to be apolitical, and I guess they would have thought this was entering into the political fray. And so I'm sure the chief was probably trying to be as little involved as possible, and would have viewed that as contrary to his principle that we should try to be as unpolitical as we can be.
So this brings me to where I think was the final act of the courts, at least vis-a-vis the 2020 election, which was the denial of cert, right? So ordinary non-expedited review in the Pennsylvania late arriving absentee ballot cases, where 3 justices said they would have granted, right? So Thomas, Alito, and Gorsuch write opinion saying, hey, this is actually an important issue. This being the independent state legislature doctrine, now that everyone agrees that it would not have made a difference in Pennsylvania and therefore in this election, we should decide it in order to provide guidance going forward. Wink, wink, guess how we're going to decide it. And what strikes me about that is not that Thomas, Alito, and Gorsuch dissented, but that only Thomas, Alito, and Gorsuch dissented, right? That Justice Kavanaugh, who had already signaled his support for this theory in the Wisconsin case, necessarily voted to deny cert, because if he had voted with the 3 dissenters, that's 4. That Justice Barrett, right, necessarily voted to deny cert. The chief, to me, Paul, right, that was the closest the court came to saying, guys, we're, even though we've said before, this is an important issue that we want to decide at some point, just this is all too toxic. We're just not touching this at all.
Yeah, I think that may have more to do with the court than with the election. I think the court has been trying this winter and spring to keep its head down and be as invisible in general as it could be. It could have been much more aggressive in deciding abortion cases, in gun cases, and other really, really hot button issues. And this would have been another one if they had taken this case, even though it wouldn't have affected the outcome of the election after the fact, just to get involved in saying that we have the power to second guess the state Supreme Court of Pennsylvania about its interpretation of state law. Would have been another one that would have been controversial, to say the least. And I think they were trying to avoid that. And certainly Roberts and Kavanaugh were trying to avoid that. What's interesting is they didn't need them. They could have granted cert with 4 votes just by getting Amy Coney Barrett. And it may very well be that she, having gone through that rather controversial last minute confirmation process, was listening to John Roberts and was saying to her, you do not want to be the fourth vote to grant cert in a case like this about the Trump election, when you were the person forced through by Trump who said the Supreme Court's going to decide the election. You can be as conservative as you want to be, but let's wait till next fall. And that is where they're going to be. I mean, if you want to see the docket for next year in the Supreme Court, it's going to be guns, affirmative action, abortion. I mean, it's all.
So this is the segue to the last part of what we had planned to discuss. And I do want to encourage folks who are watching, please do, feel free to start putting some questions for us in the chat, because we do mean to leave time for Q&A at the end. So that gets us, Paul, to sort of the Supreme Court's official sort of, conclusion of its relationship to the 2020 election. But as I think everyone sees and knows, the conversation about the election has not ended, and we've seen a number of states, right, using still unsubstantiated concerns about the integrity of the 2020 election as justification for ever more restrictive voting rules. And so I'm curious, sort of, where do you see? So I guess there are sort of two sort of future-looking threads to this conversation. One, what do you see the Supreme Court doing if and when those laws end up in the Supreme Court? And two, sort of more generally, what are the lessons we should have taken away from what happened, in the courts in October, November, December, to try to sort of get ready for next time?
Well, a couple of things. I do want to leave a little time for questioning. I think if you're talking about things like the Georgia law, the Florida law, the Texas law that have all been passed in the last few weeks, it's sort of at the margins are intended to suppress voting by minority voters and stuff. The chances that the United States Supreme Court is going to overturn those are very, very low. They have made it clear that they're going to trust election law, state election laws and state election officials, and they're not going to let the federal courts get aggressive. And basically, they've been doing that now for years. The voter ID cases, the purge cases, they're just not interested in policing that through the federal Constitution. And so the only real remedy for that is at Congress with the pending For the People Act and the John Lewis bill. Those things could be very effective if they could figure out a way to get it through the United States Senate. But no, I don't have any hope for the Supreme Court. But the lesson coming out of the election here is that the court is going to be potentially very aggressive in 3.5 years of pushing, of going after state courts as well for being too willing to relax voting rules and make it easier to vote. And so, we have to, I think, take the message out of this that the court has reserved for itself the power to decide the next election if it has that opportunity. The rhetoric of the conservative justices has not been shy about that at all. But the other thing I wanted to mention while we're still talking here, Steve, is there was this January 6th event. Leaving aside the insurrection piece, there was this whole question of how do you count the votes and what is the power of Vice President Pence to weigh in and decide which electoral votes should be counted and which ones shouldn't when he was presiding over that joint session of Congress that got so rudely interrupted there on January 6th. And there was a case actually filed in the Supreme Court on January 6th by Louis Gohmert, the congressman from your current state of residence, Steve, and asking for the Supreme Court to hold that the Vice President has the power under the 12th Amendment to decide which electoral votes should be counted and which ones shouldn't. And that the federal statute called the Electoral Count Act that gives that power to others is unconstitutional. The court slapped that one down, but not until the day after. It was actually dismissed on January 7th. But there is this whole other issue out there that I've been working on, which is how do we fix the electoral system so that we don't have the kinds of abuses we started to see with legislatures threatening to overturn the vote in their state, with members of Congress objecting to the electoral votes cast by states, based on sort of spurious fraudulent claims. And so there was a lot of work to be done legislatively to try to make that system work better, even aside from the whole issue of vote suppression and what Congress needs to do about that as well. But this is really a time when the pro-democratic forces need to get Congress going, because the courts are not going to be there after the last 4 years.
So I guess I have two follow-up questions, and then I want to turn it over to the audience questions. So the first is, I think it will come as a surprise to some, although I would not include myself in that category, that Congress has the power to create uniform rules for federal elections.
Mm-hmm.
Do you think there's any ground on which, if any of these laws actually get through the Senate, which is my second question? Do you think there's any chance that like the courts, especially these courts, might actually revisit Congress's power to enact such uniform nationwide voting rules, given the sort of concerns about the hyperpartisan nature of the current courts?
Yeah, well, I don't think there's any doubt that if the For the People Act passed, and it's a massive piece of legislation with literally 50 or 100 different things that it does to improve American democracy, that the current Supreme Court would find some of it goes too far constitutionally in a whole variety of ways. But it would change the burden. It would basically mean that Congress had spoken and the anti-voting forces have to come in and try to take those out. So it would make a huge difference. But the reason why Congress gets to do this is because while the Constitution says state legislatures can set the process for electing federal officers, including like members of the Congress, that Congress can make exceptions. And Congress has always made exceptions. The reason why we have members of the House elected from single member districts is because there's a federal statute passed by Congress that requires that you elect them from single member districts. It used to be that some states elected all their members of the House at large. The whole state just voted for everybody. And so the Congress has a major role constitutionally in regulating federal elections, not state elections, but federal elections. And so I think if it could possibly get through the Congress, it could make a huge difference. Whether or not they can get the 50 Democrats to both agree to get rid of the filibuster and all vote for the bill seems quite dubious at the moment, but we'll have to wait and see, I guess.
So that's my second question. So I'm sure you saw yesterday's comments by Senator Manchin, who, as I think we can say, as the most conservative Democrat in the Senate, holds a fair amount of power right now. So I'm paraphrasing, but my read on Manchin's comments was that he has lots of problems with the We the People Act itself, but that he would support legislation that, for example, restored nationwide pre-clearance right under the Voting Rights Act. So I guess my question is would that be like, how important a step would that be if that could get through? And do you actually think there's any chance that the Democrats, that would be the line in the sand on which Manchin and Sinema would actually agree to limit the filibuster?
All right, so let's back up here just so people understand. There was a thing called the Voting Rights Act, Section 5, which
there was a thing called the Voting Rights Act,
right, which said that some states, primarily the Deep South, whenever they changed their election laws, had to go to the Justice Department to get permission in advance. It was called pre-clearance, and that was held unconstitutional in 2013 in a case called Shelby County that I'm sure many of you know about. And so they've been trying to figure out a way to get pre-clearance restored for the southern states ever since. Congress hasn't been able to do it, but they have this John Lewis bill that's pending now that would do that. And what Mr. Manchin said yesterday is, why do we want to do this just for the southern states? We should do it for all 50 states. Any election law change in the whole country should have to go to the Justice Department in advance for an assessment of whether it has any negative effects on the voting power of minority voters. Would that be okay if they did that? Yeah, that'd be very beneficial to the rights of lots of people. The chances of that passing seem to me infinitesimally small, because you have many, many states out there with very little in the way of a track record of discriminatory voting laws, whose congressmen and women are not going to vote for a law that subjects their election system to that kind of rigorous federal supervision and oversight. It's really quite burdensome to be subject to pre-clearance. Every time you want to move a polling place, every time you want to change anything about eligibility to vote or timing of the calendar or anything, you have to go and get preclearance. And so it is not fun to be under preclearance. And the idea that all 50 states and their members of Congress are going to vote to subject themselves to that seems quite unlikely to me. But maybe I'm missing something.
So this is a good segue to one of the first questions in the chat that I want to flat, which is right, how can we get to a genuinely nonpartisan approach to work through some of these issues and try to undo some of the attempt to enshrine the former guy's hyper-partisan view of the Supreme Court and U.S. courts in general? And just, I guess, Paul, more generally, like, to me, it seems like one of the most unfortunate developments in this space has been the extent to which this has been hyper-partisanized, right? Where there seems to be no middle ground on questions of election law and voting rights these days. And do you have thoughts about how we push back against that?
It's very difficult because it reflects our politics in general. There is essentially no middle ground anymore. There are basically liberal Democrats and conservative Republicans in the Congress, very few in the way of moderates. Manchin is kind of an exception that proves the rule. And so it's hard to bridge those gaps. And now we have a Supreme Court where you have 6 very conservative Republican appointees and 3 very liberal Democratic appointees. So that begins to mirror the polarization of the country. And you have this idea among some Republicans, not all, but some Republicans, that too many people are voting. And that means that the real Americans are going to be disempowered, by which they mean their people. And so the idea of democracy itself is not considered an important value by a lot of people in this country. It's really a remarkable development. But if you talk to Republican members of Congress, they don't use the word democracy. They have been taught that this is not what we are. We are not a democracy. We're a republic, which means that we can have restrictions on voting. And so, I think this is a long process of trying to get back to a time when we had more civil discourse and more uniform respect for basic democratic values. It's a big problem, no question about it.
I see Jack McKenzie has his hand up. Jack, do you want to unmute yourself and ask your question?
Thank you very much. And hello, you guys.
Hello.
Please use Bush against Gore in a paragraph. Tell me where it stands. I thought that for years they were so ashamed of it that they wouldn't talk about it. But now, of course, some people have raised it. So I guess it was Thomas most recently. I'm not sure. So has it become legitimized?
Go ahead, Steve.
It's a great question, Jack. Thank you so much for raising it. I guess I don't know. So I think the question, Jack, is what the it is, right? Because there's a lot of different things that are the Supreme Court's decision in Bush versus Gore. The specific holding that the constitutional holding that there was an equal protection violation, that Florida had discriminated by authorizing hand recounts in some counties, but not others. Paul, you should correct me, but I don't think that has gotten any traction. I don't think that's the kind of argument that anyone's really backing these days.
People are making them all the time. They just lose.
Right. And so that was, Jack, the central sort of constitutional holding, right, that of the majority opinion. I think the part of Bush versus Gore that is gaining significant traction is the Rehnquist concurrence, which did not command a majority at the time, which rests not on the idea that the Florida Supreme Court was discriminating among Florida voters, but rather on the idea that the Florida Supreme Court had committed the separate sin of overriding the state legislature when it came to the procedures and the timetable for recounting the votes. That was until October, Paul, right? That was the most sort of thoroughgoing articulation of what we now call the independent state legislature doctrine in a Supreme Court opinion. And so, Jack, I think if the question is sort of which part of Bush versus Gore, is gaining traction, it's that part, And what's remarkable about that is that in 2000 was too crazy, right, to gain the majority position. And now it's become just almost inevitable that in an appropriate case at the right time, a majority of this Supreme Court is going to adopt it. I think we have, so Paul, there are a couple of questions in the chat about court packing, which I want to get to if we have time, but there's a question from Tom Sewer. Is there any prospect the court could intervene in the egregiously gerrymandered congressional electoral districts? For example, here in North Carolina, an almost 50-50 state with very few competitive congressional races. Do you want to say a word about Rucho?
Yeah, that's the case I lost in the Supreme Court. And as you noted,
listen, Paul, you've at least won some, right? I'm over three.
But you noted I argued a lot of Supreme Court cases about election law. I've lost most of them 5-4, and that was one of those. I mean, the court has held now in a case out of North Carolina that we are not going to do anything about gerrymandering. That this is an issue that's too complicated for the federal courts to handle. And so what remedies there are for gerrymandering have to come in other ways, either in state courts or from popular demands for more fair maps. And we're starting to see a popular movement spring up. In a bunch of states, they're forcing independent commissions that are going to draw the lines on the politicians. And I think after we all the lines get drawn again in 2021, once we see the kind of gerrymanders we're going to see again, there will be more efforts by people to do something about it, to take that power away from the legislatures. But no, the Supreme Court is not interested in helping out on this problem at all. Well,
and the irony to me, Paul, right, is that of course the court has always allowed for litigation over racial gerrymandering claims. But now what the court has done is it's armed states with the power to say, no, we're not racially gerrymandering, we're just partisan gerrymandering, which of course in many states, or at least in many parts of many states, it's not that big a difference.
Yes, that's true.
So there are two questions about court packing that I'm going to sort of roll into one, which is, one is sort of general thoughts about it. The other is there a pragmatic argument for it? Or sorry, is there an argument for expanding the size of the Supreme Court that's not just about progressive pragmatism? I'll take one shot at this, Paul, and then let you have the last word.
Okay.
So, historically, the size of the Supreme Court was tied to the number of circuit courts because the original sort of model had the justices much more actively involved in circuit courts, right? I mean, they were actually part of their circuit courts for many of the decisions all the way up to the 1860s. And so, Paul, I think the strongest historical argument for a non-partisan, non-political reason for expanding the Supreme Court is that today we have 13 circuits, right? Not 9. I'll just say that seems pretty transparently pretextual to me, that the Supreme Court is not overworked. It's in fact hearing fewer cases every term than it's heard since the Civil War, right? And that sort of the larger, and that in any event, this is never going to happen so long as there is either a filibuster or, the current status of the Senate. So I think, to me, right, what this conversation drives home is that there ought to be a much broader court reform discussion that isn't fixated on like the shiny sides of the Supreme Court issue, but actually looks much more sort of micro level at ways we can increase access to the courts for resolution of these kinds of claims.
I would only add that while it's true that Congress has the power to change the number of justices and did so for many, many times up until about 1867, often for very political reasons, that we have now gotten to the point where it's kind of viewed that we have a fixed number of justices, and it will take a lot politically to convince the Congress to exercise this power. We heard a lot of talk about it at the time of the Barrett confirmation process, but that was a time when the Democrats thought they were going to get a lot more seats in Congress than they ended up getting. And so this is completely off the table. And I think as time goes on, it will get more and more off the table. It has this big downside, which is if it's done for transparently ideological reasons, it makes the court even less legitimate and more like just another way we fight out our ideological.
And then it becomes a race to the bottom where the Supreme Court in 25 years has 37 justices and no legitimacy.
Yeah, well, that's the other thing. You get this tit for tat. As soon as the other party takes over, they would add a few more. And, you know, the other thing is Joe Biden has always been totally against this idea and spoken out very aggressively against it. You may have seen some commercials if you watch the right cable news show where they quote him on this. So I don't think this is even this is a non-starter. They did the classic thing Washington does. They appointed a commission to study the question, which means it's not going anywhere.
But I do think what it underscores is a point I think on which we can end our chat, which is that there are much more, I think, plausible, realistic, and in some respects important reform conversations that don't start and end with the number of justices on the Supreme Court. So we're out of time. I think we could probably go for about 4 more hours, but I just want to say thank you, Paul, for taking the time to have this conversation. Thanks to all of you for joining us. Thanks to Carol and the Amherst staff for all the arrangements, and happy reunion, everybody.
And let me add my thanks. Everybody enjoyed the reunion. Thank you all for finding some time to listen to us jabber on. Appreciate it. Take care.
Have a great Friday, everybody.
Thank you all so much.